Good afternoon, everyone. Thank you. There are scattered seats in various places, so I don't know if folks can. Well, there aren't really many, but there's one down here in the front, a couple over there. Hello, everyone. My name is Avi Cover. I'm the director of the Institute for Global Security Law and Policy. Very happy to have you here all today to hear from Ben Weisner, who will speak on defending the Constitution in the age of Trump. In response to questions from reporters just last week, President Trump said he would be transferring Saifullah Saipov, the immigrant from Uzbekistan, charged with plowing a pickup truck into 8 individuals, or killing 8 individuals and injuring about a score more, that he would be transferring him from the civilian justice system to the military system at Guantanamo. President Trump eventually walked back those remarks, but they're part of a pattern that we can see on the campaign trail. Mr. Trump called for waterboarding and torture to come back, and of course he brought about matters such as a Muslim ban that right now the government is litigating and realizing to some fashion. President Trump ran on a promise that he would relax military rules of engagement in fighting suspected terrorists throughout the world, and he's done that as well. Hence, we learned just about 2 or 3 weeks ago with the death of 4 soldiers in Niger, which seemed a bit of a surprise to many in Congress, that the U.S. has troops in Niger. Indeed, there are over 6,000 U.S. forces operating in Africa today. So how is it that so many of these old practices, seemingly discredited, are back? Well, we're very privileged to have today with us Ben Weisner from the ACLU to discuss these issues. He is the director of the ACLU's Speech, Privacy, and Technology Project. For nearly 16 years, he has worked at the intersection of civil liberties and national security, litigating numerous cases involving airport security policies, government watch lists, surveillance practices, targeted killing, and torture. He appears regularly in global media, has testified before Congress, and is an adjunct professor at NYU Law School. Since July of 2013, he is the principal legal advisor to NSA whistleblower Edward Snowden. He has the distinction, with a number of others, of having been blocked by @RealDonaldTrump, Trump, the president's Twitter handle, which is actually the subject of a lawsuit contending this sort of selective blocking amounts to impermissible First Amendment viewpoint discrimination. Ben is a graduate of Harvard and a law school graduate of NYU, was a clerk to Honorable Stephen Reinhart of the U.S. Court of Appeals for the Ninth Circuit. Please join me in welcoming Ben.
Thanks for that very formal introduction, and I say formal because Avi Cover and I have known each other since we were very, very small children, something that I would have expected him to mention. So thank you for inviting me, and thank all of you for spending part of your evening with me. Let me start by stating the obvious. Every president in the history of this country has violated the Constitution. But I don't think that any major presidential candidate before Trump has ever campaigned so explicitly on a platform of violating the Constitution. Recall, as Avi just did, that candidate Trump stated that he would establish a total and complete ban on Muslims entering the United States. As for Muslims who were already here, he stated, "We really have to look at profiling them. We're going to have to look at the mosques. We're going to have to look very, very carefully. We have to go and check the mosques." He defiantly advocated the use of waterboarding and other forms of torture, stating that he loved waterboarding and that he, quote, would absolutely authorize something beyond waterboarding. During the campaign, one conservative commentator observed, "When Trump makes claims like these, the press takes him literally but not seriously. His supporters take him seriously, but not literally." Well, whether they took him literally or seriously, or neither, or both, the fact is that the American people elected Donald Trump, the 45th president of the United States. And the critical question for us, I think, is how could someone who campaigned on such a horrific platform actually win the presidency? And in thinking about this question, I realized I had to give a different talk than the one that I had intended to give tonight. I had been planning to run through a litany of Trump's most odious policies and actions, a parade of horribles, if you will, and then share with you how the ACLU was either challenging or planning to challenge those policies. But you don't really need to hear that. You probably spend much too much time on Twitter and Facebook venting about the latest Trump outrage. You're probably quite familiar with the legal challenges that have been filed to push back against them, and if I'm wrong, you'll have plenty of time in the Q&A to ask me about them. So instead, I thought I would offer some thoughts about how we arrived at this moment in our history. They are not comfortable or comforting thoughts, but I think they say something about what it will mean to resist Trumpism effectively. So first, let me acknowledge that I was at least as shocked as anybody that Trump was elected. This was a traumatic event, not only because Trump had run on a platform of unabashed white nationalism, but because virtually every pollster and expert had assured us confidently that he was going to lose. So we had to deal not only with the grotesque reality of Trump as president, I'm going to say what I really think tonight, but also with the sense that perhaps we couldn't trust our most trusted sources of information. So it's no real surprise that many people have been struggling to make sense of what happened, and that many people believe that there must be some kind of external explanation for this aberration. For a few days after the November election, my social media feeds were full of urgent pleas to raise money for audits of the electronic voting machines in Wisconsin, Pennsylvania, and Michigan. Coincidentally, the 3 states that determine the outcome of the election. Now, don't get me wrong. I think audits of electronic voting machines are very important and they should be routine. But there was no small measure of wishful thinking in these efforts. Within days, a new culprit had emerged: fake news on Facebook. Everywhere I went to speak, people wanted to know, what are we going to do about the scourge of fake news that elected Donald Trump president? And then very quickly, the most enduring explanation took hold. It was Vladimir Putin and the Russians. This was the most appealing explanation because it was the most foreign. This cannot be about us. It was as if the Trump presidency could only be the result of a nefarious Russian plot or a secret Facebook algorithm. Now, the point here is not to downplay any of these issues. I am worried about the current information ecosystem. It is a bad thing when a political campaign is hacked by a foreign intelligence service and its emails are published around the world. And in a close election, anything can be a proximate cause of the outcome. But when I hear friends and colleagues respond to the latest Trump outrage by saying, "This is not America, this is not us," my response is, really? Who do you think we are? Deportations of non-citizens is not American? Cozying up to dictators is not American? As I recall, 2.5 million non-citizens were deported during the Obama administration, and every president in American history has cozied up to dictators. I think Trump is profoundly American. And I think it's dangerous to view him as some kind of foreign plague. Because if we think of Donald Trump as something that happened to us rather than something that we created, we might be looking for salvation in the wrong places. The CIA will save us. The generals will save us. Or even Robert Mueller will save us. To defend the Constitution in the age of Trump, we need to understand how we got here, and we need to define the threat carefully. If the problem is just Donald Trump, the solution might be Mike Pence. And I don't want to be part of a resistance movement whose goal is to put in power a warmongering, climate-denying theocrat who happens to be less vulgar than Trump. So how did we get here? This is too big a question for one lecture, obviously. We would have to examine, at a minimum, the history of xenophobia and racism in this country, the degradation of our media by talk radio and by Rupert Murdoch, perhaps the ways in which globalization and the information economy have created winners and losers, and how those distinctions map onto our outdated electoral college system. I don't have time for all of that tonight. Today I want to look at just one factor that I believe contributed materially to the rise of Trump. And my argument this afternoon, or perhaps my provocation, is this: that our distorted politics or ideology of national security paved the way for a president who ran on a platform of erecting a border wall and banning Muslims and torturing prisoners, and also made it more difficult for us to rein him in. So what do I mean when I say the ideology of national security? Let me start by saying what I don't mean when I use that term. I'm not referring to national defense, which we might define as a nation's use of military power and intelligence assets to maintain its survival. I'm not referring to public safety, which we might define as the use of police powers to protect the public from crime or other non-existential dangers. I'm referring to something more nebulous, a kind of civic religion that has arisen over the last many decades in this country, and particularly since the 9/11 attacks, and has enshrined itself as our nation's paramount and defining interest. And this ideology or theology of national security is predicated on a series of foundational myths or articles of faith that I'll argue are highly questionable, yet rarely questioned. And these baseline assumptions are so commonly accepted that we've become desensitized to how truly extreme and anti-democratic they are. So I'll explore some of these myths or tenets in detail and then explain why I think they're so consequential. By allowing this category error to metastasize without clear boundaries, we've dignified a state of perpetual constitutional exception. Collectively, we have diminished our democracy and weakened critical oversight mechanisms. And in a time of genuine constitutional crisis, such as the one that we may be experiencing now, the ideology of national security has left us with fewer tools of resistance at precisely the moment when those tools might be most needed. So this is going to perhaps feel to some of you like a long digression, but I promise I will circle back. So the first and by far the most important tenet of the national security priesthood is this: we live in uniquely dangerous times. An alternate formulation of this core tenet is that we face an unprecedented threat. Now, despite the presence of words like unique and unprecedented, this tenet would appear to be evergreen. It is exemplified by Senator Lindsey Graham's remarkable but also typical statement in 2015 that we have never seen more threats against our nation and its citizens than we do today. So let's paraphrase Senator Graham. The framers of the Constitution may have had certain ideas about the need to restrain government, but they never faced a threat like Al-Qaeda or ISIS or cyber attacks by state or non-state actors. We saw the same kind of thinking in former White House counsel Alberto Gonzalez's dismissal of the Geneva Conventions as quaint and obsolete. These statements are nonsense. Relative to population, the casualty figures of the Revolutionary War were staggering compared to more recent conflicts. That war represents the very definition of an existential national struggle. And the authors of the 1949 Geneva Conventions had just emerged from a total war in which 50 million people, nearly all of them civilians, had been killed. To call those people naive is the height of narcissism. So let's engage in a thought exercise. What would the framers of our Constitution, or the drafters of the Geneva Conventions, have made of our society in which only 1 in 4 million people is likely to die in a terrorist attack, but the government nonetheless routinely frightens the public with color-coded threat alerts? I don't think they would be impressed. Now, a corollary of this foundational myth is that today's terrorists are uniquely lethal supervillains. Ordinary prisons can't hold them, and of course, they can never be released. And so we heard the nation's top uniformed military officer warn us in 2002 that Guantanamo housed the worst of the worst, the sort of people who would gnaw through hydraulics lines in the back of a C-17 transport plane to bring it down. In New York City, we saw the deeply cynical protests by local elected officials who opposed holding the trial of the alleged 9/11 perpetrators in federal court in Manhattan. The result of that effort is that more than 16 years after the 9/11 attacks, the trial of the alleged perpetrators has not even begun, something that should be a source of embarrassment to all of us. Now, it's important to qualify, this view of terrorists as supervillains is not shared by everybody in the security state, and you hear very different things in private. About a decade ago, I was invited to dinner with a senior military official, one who would go on to serve on the Joint Chiefs of Staff. And I said to him at that dinner, if you closed the Guantanamo prison today and offered each detainee the weapon of his choice and dropped him off on the battlefield of his choice, they would collectively do less harm to this country than you are doing by keeping the Guantanamo prison open. His response? A high five. But the fact that this person would never acknowledge that view in public is the consequence of a perverse, upside-down politics of national security. So those who proclaim that today's Muslim terrorists represent an unprecedented threat to our way of life, that our existing laws, courts, and institutions, even our prisons, are inadequate in the face of this threat, that we have no choice but to dispense with core principles, including even the prohibition against torturing prisoners, to defeat this ruthless enemy, that in short, 9/11 changed everything. Those people have been extolled as hard-nosed realists, warriors who are willing to take the gloves off. By contrast, those of us who defend the vitality and viability of our constitutional system, who insist that our existing institutions are equal to the task, who demand that we abide by core principles, including fair trials and humane treatment for prisoners, even if that means that terrorism suspects will be released and political leaders will be prosecuted, who in short don't believe that the threat of terrorism requires us to abandon our core principles, we're dismissed as weak and naive, afflicted by a pre-9/11 mindset. Now, this insistence on the discourse and language of war, I think, says less about the nature of our enemy and our threat, and more about the identity needs of these would-be warriors. And it's necessary to ask, is it possible that Lindsey Graham is right and I'm wrong? That terrorism is in fact the existential threat that he would have us believe it is? And that but for the wars and the aggressive counterterrorism policies that he has advocated and that I have opposed, we would have seen dozens of catastrophic attacks in the last 16 years. Of course it's possible. As the noted philosopher Donald Rumsfeld once said, absence of evidence is not evidence of absence. This line of argument recalls the old joke. A man is standing in the middle of Times Square, holding a sign that says, "Tigers, keep out." A passerby walks up to him and says, "Sir, what are you doing there?" "There are no tigers in New York City." And the man nods knowingly. It's working. This is the conundrum. We can't say what the world would look like if we didn't throw hundreds of billions of dollars at this problem. But if a lack of terrorist attacks is evidence that our strategy is working, and more attacks are evidence that we need even more counterterrorism resources, then we seem to be trapped in a one-way ratchet. I would add that if our intelligence community were routinely thwarting deadly attacks, it would be in their nature to boast about it. Recall that Attorney General John Ashcroft interrupted a visit to Moscow in 2002 to announce to the world in a creepy, grainy video that the United States had captured Jose Padilla, who was allegedly involved in a plot to detonate dirty bombs in US cities. Now, even at the time, the evidence for that assertion was scant. We now know it was always more fantasy than threat. And government officials have made similarly breathless announcements about thwarting of comically inept terrorist attacks or plots, real or imagined. One of my favorites was the so-called Sears Tower plot, a nefarious plot to knock down the iconic tower so that it would fall into Lake Michigan and create a tsunami. Vice President Dick Cheney described that plot at the time as, quote, a very real threat. The truth is, as the security expert Bruce Schneier has written, there aren't a lot of terrorists out there. America is full of big guns and soft targets. If it were also full of sleeper cells, we would know by now. This leads us to an uncomfortable question. How have the leaders and defenders of the security state persuaded the citizens of one of the safest and most secure societies in the history of the planet that the Huns are perennially at our doorstep? I wish I had a good answer to that question. A second core tenet of the national security ideology is that security itself is our paramount national interest. This view is widely held and often stated. Even the United States Supreme Court, which should know better, has written that it is obvious and unarguable that the security of the nation is its preeminent interest. Is that really right? It's certainly not clear that the framers of the Constitution would agree. As the journalist Bart Gellman has written, the preamble to the Constitution identifies not one, but the 6 basic purposes that we the people intend our government to advance. Fourth among them is to provide for the common defense. Union, justice, and tranquility precede that goal. Welfare and liberty follow. As Gellman says, there's a tone of Catholicity here. We the people care a lot about the common defense, but defense has peers in our pantheon. It's now entirely common for us to refer to the president as the commander-in-chief of the nation, not of the armed forces, a formulation that misperceives the president's constitutional role, even as it makes all of us soldiers as we sit at our computers scrolling through tweets and deleting emails. A corollary of this myth is that if it makes us safer, we should do it. All too often, in our conversations about terrorism, it seems that the only question we should be asking is whether a proposed government action will keep us safe. But we know from other non-national security contexts that this framing is at best incomplete. We knowingly reject all manner of policies and regulations that would demonstrably make us safer. We could reduce deaths from automobile accidents quite significantly if we used advanced technology to strictly enforce speed limits. We could require that every new car be fitted with a breathalyzer device linked to the ignition, so that no car could be started by someone under the influence. We could have sobriety checkpoints every mile. Now, some of you may be nodding, thinking that these are good ideas. Great. You can use the political process to advocate for policies like these. And if and when they're proposed, there will be voices on the other side arguing that increases in road safety are not worth the cost in liberty of being issued automatic speeding violations every time we exceed the posted limits, or having TSA-level security on our roads and highways. The real question is, how much safer do you want to be? And how much are you willing to give up in exchange for that increase in safety? You are all already pretty safe from terrorists, and you should be wary of political rhetoric that leaves little room for other core constitutional concerns. A second corollary of this myth allows the high priests of the security state to position themselves as the real defenders of civil liberties. I often hear arguments like this one. If you think these policies are bad, just wait until there's another attack. The public will demand much worse. The implied takeaway is that we should gratefully allow the erosion of our rights in order to prevent the erosion of still more rights. This formulation is an unhelpful straw man. It's a straw man because no one, I think, is arguing that our police and military and spies should unilaterally disarm. All of us support targeted counterterrorism measures that are proportional to the threat. And it's unhelpful because it tells us nothing about where difficult lines should be drawn. Which brings us to our next core tenet. We, the public, should defer to the expertise of national security officials. And now this anodyne-sounding principle has been at the heart of the security state's successful efforts to neuter constitutional oversight by the courts and Congress. Of all the tenets of the national security state, this one would have seemed the most alien to the Constitution's framers. The structure of our constitutional system is predicated on mistrust of aggregated authority. The very purpose of divided government and of constitutional protection for a free press was the framers' belief that leaders would use their power for improper purposes, not because they were evil, but because they were human. So what the leaders of the security state called deference to their own expertise, the framers would have recognized as a conflict of interest. So for example, when the ACLU brought a lawsuit against CIA officials and contractors for the mistaken kidnapping and brutal treatment of our client, Khalid el-Masri, it was the CIA itself that invoked the so-called state secrets privilege and successfully pressed for the dismissal of the suit on grounds that litigation of our claims against them would harm national security. Put otherwise, a torture victim's lawsuit was dismissed in deference to the expertise of an affidavit submitted by the perpetrators themselves. Now, secrecy doctrines like the state secrets privilege are the method most often used to enforce this principle of deference. Executive branch officials are literally indoctrinated, this is their term, not mine, into the world of security clearance, which I prefer to call the deep state omerta. And the security clearance regime allows government officials to put forward a corollary of this rule. If you knew what we knew, if you saw what we saw, you would understand why we have to do what we do. When you hear language like that, be sure to keep in mind that the most damaging decisions affecting our national security have been made by officials with access to the most closely guarded secrets. A few years ago, I had the opportunity to discuss state secrecy and the state secrets privilege with the former Chief Justice of the Israeli Supreme Court, Aaron Barak. I asked him, how do you respond to government demands that courts defer to their expertise? He described a lawsuit in which human rights organizations in Israel had challenged a military proposal to erect a security wall that would cut off Palestinian civilians from their farmlands. Military officials responded to the case by insisting that the court defer to their expertise and not second-guess the planned route of construction. Justice Barak told them, "You are the experts in national security, but I am the expert in proportionality." The court held that the planned wall had to be rerouted to mitigate the harm to the local population. And this kind of approach has allowed the Israeli Supreme Court to issue important precedential decisions in a range of areas, including torture, targeted killing, and other highly sensitive security issues, even as their US counterparts have dismissed the same cases without any adjudication of the law or facts on the basis of government claims of secrecy. A fourth tenet of the national security state, which is that national security officials who break the law do so in good faith, and advocates who seek to hold them accountable do so in bad faith. This tenet holds that our national security officials are uniformly honorable public servants, working under extreme pressure, while human rights advocates who second-guess their decisions are practicing a kind of lawfare, asymmetric warfare waged from the safety of our fifth column. This term, lawfare, has generally been defined as the strategy of using or misusing law as a substitute for traditional military means to achieve an operational objective. Remarkably, this is how many leaders in the security state and their apologists tend to view the efforts to hold them accountable for grave violations of the Constitution and human rights norms. The Brookings Institution's Benjamin Wittes, who is the editor-in-chief of the Lawfare blog, you may know him. He has emerged as a kind of celebrity of the anti-Trump resistance, often tweeting pictures of baby cannons. This same Ben Wittes has defended the notorious Department of Justice torture memos, which purported to authorize interrogation techniques that the US has long deemed criminal, as the good faith work of lawyers who were, in his words, addressing very hard questions under extraordinarily difficult circumstances. By contrast, here is how he describes a human rights organization, where Avi Cover used to work, that criticized the Obama administration for its political decision to look forward and not backwards, and not to investigate the architects of the Bush administration's torture conspiracy. In Wittes's words, "What Human Rights First calls accountability for torture is, in my book, the criminalization of policy differences, nothing more or less." In 4 words, nothing more or less, he breezily dismisses a deeply established body of domestic and international law, including treaties to which the U.S. is signatory, and accuses human rights defenders of pursuing a partisan political vendetta. Now, this is, of course, exactly backwards. It was the torturers and their apologists who were politicizing the law, not human rights advocates who were criminalizing politics. But this sense of outraged dignity at the notion that honorable public servants who were protecting the nation could have their actions judged by naive idealists is a common trope of national security discourse. The result, and I promise you I'm coming back to Trump, is that there is virtual impunity for any senior security state official who insists that his alleged misconduct was carried out under the banner of national security. And so, for example, virtually every lawsuit brought by victims of the Bush administration's torture regime has been dismissed without any adjudication of either the law or the facts. Now, this, of course, means that the perpetrators have escaped accountability and the victims have been deprived of a remedy. But of at least equal importance here, our system of justice has been deprived of a definitive adjudication of the lawfulness of torture. So should we be surprised when a new president feels free to relitigate this question? Can we even call it relitigation when we were never allowed to litigate it in the first place? So let me sum up. The ideology of national security has taught us, first, that the world is always a very scary place, and that Islamic terror is on par with earlier existential threats to the nation. Second, that security should be our primary national concern. Third, that the courts and Congress should generally defer to the expertise of the executive branch on national security questions. And fourth, that executive officials should be exempt from legal accountability because their activities, even their abuses, are carried out in service of the nation. Should we be shocked that a demagogue who demonized Muslims, advocated building a wall around America, and called for a policy of torturing terrorism suspects found fertile ground in the America of 2016? To me, it's more than a little ironic that many of the national security actors and cheerleaders who brought us this ideology have emerged as loud critics of President Trump. And they seem to have little sense that they spent the last several decades helping to lay the groundwork for a fear-based candidacy and advocating the weakening of constitutional constraints that were put in place precisely to protect us from a malignant actor like Trump. So you can understand why I'm not enthusiastic about joining hands in resistance with unrepentant Iraq war hawks and torture apologists. But you may be surprised after that litany that I do see a possible silver lining in the events of the last 9 months. It's kind of a paradox, but this revulsion, this widespread revulsion towards Trump, may actually have the effect of weakening the hold of the ideology of national security. When Bush was president, when Obama was president, and there was a terrorist attack or thwarted terrorist attack, immediately there would be demands for additional surveillance authorities, new government powers. More often than not, those demands would be heeded, and those new laws would be passed. But observe what's happened under Trump. There is a lot more talk of resilience and courage. And some of the very national security actors who would have overreacted to a terrorist attack under President Obama are now counseling that we remain calm and not overreact. And this, I think, raises a deeper question. Is fear of terrorism really as deep-seated as our leaders seem to believe it is? Or is it a kind of language or discourse that we've all grown accustomed to? I think there's reason to believe that the public might be ready and even grateful for a different kind of conversation about security and terrorism. And we saw some of this sentiment in the tens of thousands of Americans who spontaneously gathered in airports in January to protest the Trump administration's ban on refugees and visitors from predominantly Muslim countries. I'm convinced that those demonstrations played a critical role in the decisions of the judges to enjoin enforcement of Trump's executive orders. We like to think of courts as being insulated from political tides, but the opposite is true. Judges are extremely responsive. A frightened populace will contribute to judicial decisions upholding abusive policies, and a courageous populace will embolden judges to stand up for rights. We have seen under Trump a strengthening of those civil society institutions that can be counted on to push back against a national security precedent. And here I would include the press and the major newspapers, which have all seen their subscriptions spike, and the ACLU itself, which has seen its membership go from about 500,000 to close to 2 million in less than a year. So this is my note of optimism that I'm going to end on. As the German philosopher Nietzsche and also the hip-hop artist Kanye West paraphrased, "What does not kill me makes me stronger." Sometimes it takes a shock to the system to make us realize that we've been sleepwalking towards tyranny. I think everybody is awake now, and I think people are ready to fight for our democracy. So I'll end on that note, and I'll be very glad to take questions either on this or on any topic that you desire. Thank you very much.
We have a microphone?
Is there a microphone in the room? Or it's a small enough room. I can repeat the questions if people...
They're recording this, so they always like...
Oh, okay. All right.
Is that right? You need a mic?
Is there a mic? Okay.
I'll speak up. Twice in 2016, I saw an active duty military deployed in the United States of America. Once here in Cleveland for the Republican National Convention, and once at Grand Central Station in New York City, which apparently is routine. Can you tell us what became of Posse Comitatus? And why have we not heard anything about it?
The question is about the Posse Comitatus Act, which generally tries to keep military and civilian life separate. There are many other times in your lifetime where military or National Guard have been called in for one reason or another.
Well,
either.
National Guard, I understand, but this was
Yeah.
active duty military, United States Army.
Yeah, I don't know the answer to that question. I think it's something to keep an eye on. I think what I would say to even add to that concern is that we've increasingly seen not just the military or National Guard playing police roles, but the police playing military ones, and that military equipment has been flowing towards police organizations around the country, and they are now, armed to the hilt with tanks and weapons that they don't really need. We've been pushing an effort to get communities to take more control over local police to make sure that they don't, militarize in that way. But I don't have a specific answer to your question.
Yes, in the context about spying with, in the domestic realm, how does this play out in your talk? Also about groups they've been who may be marginalized, whether it be Islamic, Black, or whoever, whether it be Black Lives Matter or other groups. As you know, the FBI came out with a report about Black identity extremist groups in terms of these ambiguities. How does all this play out? As we know, we have the evisceration of the Fourth Amendment and so forth. And we also have the Patriot Act, and we have the act after Timothy McVeigh. Can these things be invoked in a very ambiguous way in terms of that?
Yeah, you, I think, are talking about the various laws that were passed in 1996 following the Oklahoma City attack and also the Patriot Act.
And the Fourth Amendment evisceration.
Yeah, I will just say on the Fourth Amendment ground, we may actually be seeing some of the seeds of optimism here. During the war on drugs, the Supreme Court and other federal courts really treated the Fourth Amendment like a dish rag and essentially allowed incredibly abusive police searches with very little regard for constitutional concerns. Since 2012, we've had a few unanimous Supreme Court decisions reinterpreting the Fourth Amendment for the digital age in a way that's positive. So in 2012, the Supreme Court said that it was a Fourth Amendment search for the FBI to put a GPS device on a suspect's car and track it for 28 days. In 2014, the Supreme Court again unanimously held that police can't seize a cell phone incident to an arrest and search it without a warrant. They have to get a separate warrant to search the phone. And at the end of this month, there's another very important Supreme Court Fourth Amendment case, in a case called Carpenter versus the United States, an ACLU case, which raises the question whether police have to get a warrant in order to go to your phone company and get historical location information about where your phone was. In this case, the police got 107 days of historical cell phone location information and used that to convict somebody without getting a warrant. That's a very important case because the government's theory is that once you disclose any kind of personal data to a third party, you have waived constitutional privacy rights over that data. And in this case, the government says that by virtue of your using one of these, you are voluntarily disclosing your location to the phone company every time you use it because you know that they have to know your location in order to give you service. In an era where we're all storing our data on other people's computers, that's really what the cloud is, right? Someone else's computer. And where the devices in our homes are soon going to be internet connected and collecting information. And if the Supreme Court accepts the government's argument, that would really be a disaster for the digital age. I think we have reason to be cautiously optimistic. Your general point is right.
COINTELPRO, are we
Yeah.
revisiting COINTELPRO?
I don't know. I mean, you mentioned the FBI's targeting of black identity extremists.
And Muslims.
And so we, when we heard that news, filed a FOIA request and are going to file a lawsuit to try to find out what documents they're holding there. But you're certainly right that surveillance falls disproportionately on certain communities. Since 9/11, it has been predominantly Muslim, Arab, and South Asian communities. In the last few years, with the rise of Black Lives Matter and the new civil rights movement, there's been a lot more law enforcement attention on that. All I can say is that we're trying to get as much information about that surveillance as possible, and where we can, we'll push back against it.
Thank you. That was a really excellent and eye-opening talk. I'm wondering if you could tell us, I know you teach at NYU, and I'm wondering if you've noticed the same thing, which I've noticed in my students. I went to law school 12 years ago, and I think, at least among the students in my class, there was a widespread revulsion towards torture. Yet when I teach human rights here at this school, I find maybe about half my students are okay with it, and half of it are sort of repulsed by it. So I'm wondering if you've noticed a similar trend. I think when you talked about the lack of accountability, when we talk about a presidential candidate who has endorsed it, we're talking about a pretty serious retrenchment against the jus cogens erga omnes violation of pretty much everything. So I'm wondering if you notice a similar trend, and then whether you have any advice on how we can reintroduce revulsion of torture.
Yeah, I candidly, I have not seen that trend in law students, and I assume that's because they self-select, and the ones who would participate in a clinic that's co-taught by an ACLU lawyer tend not to be the ones who talk about how they're comfortable with torture. Even if secretly they are, they would know not to say that in the presence of someone who spent 10 years litigating torture cases. So I don't have the empirical evidence there. The polling information is troubling enough. Donald Trump's election is a huge data point in this argument. I mean, someone who actually ran on a express platform of taking the gloves back off. I don't think that there is an immediate concern. This wasn't your question, but that the CIA and the military will get back into the business of running a torture program. I think that even though we weren't able to get judicial rulings that what they did was illegal, there is a lot of fear in the intelligence community about being dragged back through that kind of debate. And at the senior levels, there are officials who have been told by the Department of Justice not to leave the country. And I suspect that includes Rumsfeld and Cheney, who you don't see visiting European capitals right now because of their concern of being arrested by European magistrates for their role in the torture conspiracy. I wonder whether Professor Yu is traveling to Europe. So there, in that sense, there has been some kind of accountability. But I think the reason why we need constitutional rights and universal human rights is because sometimes they express values that may not be popular, particularly in times of fear and xenophobia. So it's troubling but not shocking that in the immediate aftermath of 9/11, for example, people who were otherwise pretty liberal-minded, wanted civilians bombed and wanted prisoners tortured because of that emotional reaction. And this is why we need those instruments and those rights, is so that we can, adhere to those principles even at those times. I think I'll say it this way. I think that our legal system's failure to grapple with torture has set back international human rights by a generation. That we essentially took these principles that were so clearly established, and through our state practice, and the U.S. has outside influence even in the human rights world, we put them back into play. And the fact that we still have Guantanamo open, the fact that our courts didn't hold any senior officials accountable for torture, gives enormous cover to other kinds of regimes to use these kinds of tactics, makes it much harder for us to be the kind of actor that we should be. But I haven't seen it among students.
Speaking of torture, I believe it was the ACLU who brought the lawsuit against James Mitchell and his colleague for
Bruce Jessen, yeah.
Enhanced interrogation techniques. Can you talk a little bit about that lawsuit?
I can, yeah. So there were two contract psychologists named Bruce Jessen and James Mitchell, who had no real experience as professional interrogators, but developed a torture protocol for the CIA based on reverse engineering a kind of training that the CIA did for its people and the military did in order to help them resist torture by Chinese or Soviets or others. This was the CIA's so-called Enhanced Interrogation Techniques program. And these two psychologists were on site in secret prisons. Their companies earned about $81 million from the government for implementing this torture regime, in which some people were killed. So a few years ago, yes, the ACLU, on behalf of two living victims of this and the family of one dead victim, brought a suit against Mitchell and Jessen. This was the first lawsuit brought on behalf of torture victims after 9/11 that was not dismissed at the pleading stage. In every other one of these cases, the government came in and insisted at the outset either that the subject matter was too secret, the defendants were immune, the case had to be dismissed without any litigation whatsoever, and they were all dismissed. This one, interestingly, and it was towards the end of the Obama administration, they did not intervene in the case to try to get the case thrown out. For whatever reason, the Obama administration and DOJ allowed this case to proceed. And in fact, it was set to go to trial in Oregon just a few months ago, and on the eve of trial, there was a settlement, the terms of which I don't know because I wasn't on the team, and there's a protective order about what can be said. But I will say that this was a favorable settlement for the torture victims in this case. And although it's disappointing that we still don't have a clear rule from a judge that what happened was illegal, it was an offer that they couldn't refuse. So I can't say what was in it because I don't know in the settlement.
We have a question over here.
Sure.
First, I enjoyed your presentation very, very much. Given, I think, that the heart of democracy is the election, and given also that we know now that the previous election was, if not swung, at least tampered with by a foreign national government, and given also that the movement is away from the hand counting of ballots and more toward technological counting of ballots, how do we address that?
Yeah, so there are, there's good news and bad news here. The good news is that there are experts who know how to ensure secure elections using new voting technology. And the bad news is that there's no federal law and almost no state laws that ensure that kind of outcome. So we know that we should be doing routine and regular audits of these technologies. And that there should be a law that requires that if we're going to use electronic voting, that we have audits. To date, there isn't evidence that I'm aware of that any of the voting results in 2016 were tampered with. We do have evidence that there were attempted intrusions earlier on, people or foreign entities perhaps poking around and testing the vulnerabilities of these systems. But there isn't really any reason to believe that vote totals were tampered with. But there's enough reason to be worried that that might happen in the future. So when you hear people saying we should do internet voting, that's one of the worst ideas that I've ever heard, right? I mean, but it is a good idea to use modern technology for voting. Everyone remembers the hanging chads, right? We don't want to go back to a system where votes are undercounted because of antiquated technologies. But we have to take voting security more seriously. And we really need to make this a political demand. Part of this is an artifact of our federalism. States are largely in control of federal elections, right? And they take those responsibilities with different degrees of seriousness. Some of them want to encourage voting and some of them want to discourage it. But I think that everybody has an interest in secure elections. I don't see any reason why that should be a partisan issue, because there's no reason to suspect that one side would be better or worse at manipulating outcomes, or that foreign actors would always favor one party over another. So this doesn't seem like it should be a partisan issue. It seems like something that we all ought to be able to work on together. Front row. Oh, back. Yeah.
Thanks. So your argument in favor of strong constitutional rights and not deferring to the federal government also, of course, seems to assume that courts are going to be willing to look at these cases closely, look at the facts closely, evaluate them objectively, and sometimes find against the government. Are you at all worried about this sort of strategy or the prospects of this going forward as the Trump administration sort of is reshaping the federal courts with its own appointees?
I mean, I guess I would say here, I don't think there's any difference whatsoever in the judges that are being appointed by Trump than the judges that would be appointed by any other Republican president, and that's the bad news, actually. That he seems to have turned over this function entirely to the Federalist Society, and they're just going straight from their list. So I don't think Trump cares a whit about who judges are, and it's a way for him to solidify a certain part of his base. Am I worried about this? Yeah, I mean, I still sometimes wake up in the middle of the night galled that Senator McConnell was so norm-shattering that he managed to keep a Supreme Court seat open for a year to see who would win the next election. I mean, I would have thought that wasn't possible in the democracy, but we're all learning over the last couple of years the difference between laws and norms. Things that we might have thought were laws turn out to be norms when there's no one to enforce them, right? So who do you complain to when the Senate refuses to give a vote on a Supreme Court nominee? Well, you have an election, and it was our fault for letting them win that strategy, right? And I think we're seeing the same thing with Trump on norms, right? He decided that reporters from 11 news organizations couldn't come to a White House press briefing. Is there a law there, or is there a norm there? Well, that one might be in between. I think if he selectively chooses news organizations, we probably could sue him for that. If he kicked everybody out, that's probably something a president can do. What if he decides to disregard a decision of the Supreme Court? What court do you appeal to then? There's only one, and it's Congress, and it's impeachment. But what if the party in power agrees with disregarding a decision of the Supreme Court? So much of what we sort of take for our core legal system might be on more fragile ground and might have depended on a kind of consensus and respect for these kinds of norms that someone could disrupt and overturn. So if you ask me if I'm worried, of course I'm worried. And one of the nice things, again, I called it a silver lining before, about Trump's rise, is that everyone is now acting the way citizens should act in a democracy. We should always distrust. We should always, give our money and time to civil society organizations, to newspapers. We should always be much more active as citizens than we were before. I said we were sleepwalking. I don't think anybody's sleepwalking now. Yeah.
Great. Department of Justice is complaining about the ACLU and the, over the weekend, I think, about that abortion, so-called fast one that the ACLU played on DOJ. Can you comment on that, please?
A little bit. This was
On the facts and your comments.
a really remarkable case. There are ideologues in the Trump administration and the Department of Justice who can't accept the fact that the Supreme Court has never overturned Roe v. Wade, and that the law of the land is that adults are still entitled to get abortions, and even minors in some situations, if they go through the correct procedures, are entitled to get abortions. So this was a case where a 17-year-old undocumented immigrant who was in immigration custody found out that she was 3 months pregnant and wanted to get an abortion. And the Trump administration went to enormous lengths to prevent her from being able to get that. Essentially arguing in the face of our lawsuit that there's no constitutional right to enter the country illegally in order to get an abortion. Right? I mean, just very, very convoluted arguments, weeks of very bitter and contested litigation. A federal district judge in D.C. ordered the Trump administration to allow the 17-year-old Jane Doe to get an abortion. A 2-to-1 appellate panel of the D.C. Circuit reversed and said that the government should be given time to appoint a guardian. The en banc D.C. Circuit reversed the panel immediately and ordered that she be allowed to go ahead and get an abortion, which she then did the next day. The government, a few days ago, filed an extraordinary petition in the U.S. Supreme Court asking the Supreme Court to vacate the lower court opinion and to discipline my colleagues at the ACLU who represented this Jane Doe. And the government said that the ACLU had led the government to believe that the abortion would take place on the 26th of October, and in fact took place on the 25th of October. That was when they were going to file their petition. It was misconduct by my colleagues not to notify them of the change of schedule of the abortion, and therefore my colleagues should be sanctioned, reported to their local bar associations, and the opinion should be vacated. I don't really know what more to say about it. I've never seen the Department of Justice seek sanctions for an ethics violation without citing a single ethical rule that was violated. And I think what's going on here is that the very extreme anti-abortion base of the Trump administration is furious that the Department of Justice didn't immediately appeal the appellate decision to the Supreme Court, which they could have done. And the Trump administration is trying to say, we meant to, but it was the ACLU's fault that we didn't. I don't think that strategy is going to get them very far.
So unfortunately, because I know there are a lot of questions, we are at our hour, and those who do need to go, I want to let you go. The good news is we're going to be outside having refreshments where you can pigeonhole Ben with more of your questions. I want to thank you all, and thank Ben. Please join me in thanking you.